Welcome back. Well, new drunk driving laws are sparking some controversy among Canadians. Police are now able to demand breath tests in bars, restaurants, even your home if they suspect you were driving impaired within a 2-hour window. Some experts say the changes are unconstitutional. I'm now joined by Christopher Assie. He is a Toronto-based criminal defense lawyer. He joins me in our Toronto studios today. Welcome, Christopher.
Thank you.
So let's sort of delve into this. What's the biggest concern for you with regards to these new driving laws, or these new impaired laws, if you will?
Well, there are two significant changes. One particular that is receiving a lot of attention is that the police no longer need to have any reason to suspect you have alcohol in your body to demand a roadside approved screening device demand while you are driving. So if they stop you while you're driving, prior to the changes, they had to at least have a reasonable suspicion that you had alcohol in your body. That is no longer the case. Anybody they can pick at random and say, I don't care, I don't smell anything, I know you haven't admitted to drinking, please blow into the roadside device. That is one change that's rather significant. The second change that is arguably more concerning is that it's now an offense to be over the legal limit within 2 hours after stopping or ceasing to operate a motor vehicle or have care and control of a motor vehicle.
On the flip side, if I were to play devil's advocate here, of course, the government's line of defense on this or argument is it's all about keeping people safe, and they want to ensure, and when people consume alcohol, people are affected differently. So, I mean, I'm sort of throwing this on the other side here. If it's about protection, is it going too far?
Well, first of all, we have to acknowledge the following, which is that it is not illegal in this country to consume alcohol and drive. If that was the case, then arguably that would be fine, but it's not. The government has decided that it is still permissible to have some level of alcohol in your system and operate a motor vehicle. So the real question is, what happens if a person is charged with the offense of having more than 80 milligrams of alcohol within 2 hours after they stop driving? The reality is that in order to become or to acquit yourself, you'll have to demonstrate 4 things. 1, that you were drinking after you stopped driving. 2, that you had no reasonable expectation that you would be having to provide a demand or a sample, rather, of your breath. 3, that you were your readings are consistent with being under the legal limit at the time of the offense. And 4, that the pattern of consumption is consistent with the readings. Now, the reality is that what constitutes consistent with the readings when you're at the police station is not clear. Is it 5, 10% off? Is that an acceptable margin? Many people will have difficulty in being able to marshal the proper evidence of the amount and the rate that they consumed. It's fairly easy if you're drinking, pre-standard a bottle of beer, 2 bottles of beer. But for most people, if you have a glass of wine, many people have a difficulty in their guesstimates of how much ounces there are, when they consumed it, etc.
Right.
It may, in fact, become impossible, even though you weren't impaired at the time that you were driving.
Christopher, really quickly before we have to go, can this be challenged in the courts then?
It can. Both provisions, I think, can be challenged. The one in terms of having to provide a roadside demand without any reasonable suspicion is rather constitutionally suspect, let's say. In the previous Supreme Court decisions. They found that it violated Section 8 or Section 9 and 10 of the Charter, however, was saved under Section 1.
All right, Christopher, we're going to have to leave it there, but really appreciate your time on this. Christopher Assie, a Toronto-based criminal defense lawyer, rather. Thanks a lot, Christopher.
Thank you.